Good evening. This is Crash Talk. I'm Mike Harber, your host. And tonight we're going to conclude the three-part series that we've done with Paul Vayan, a Seattle personal injury attorney. We had a little bit of a break. We had some other guests that we interjected so that we could keep things lively and moving along and hear different perspectives from different people that are in the know regarding insurance and collision claims and repair to your vehicle, total losses. And so this evening, you're going to hear the conclusion with Paul, and I hope you find it enlightening, hopefully challenging, that you don't just give in. So this is the conclusion of Paul Vayan's top 10 meritless excuses for delaying, denying, and discounting auto property damage claims. Or as I said, how to save an insurance company money. We all want to do that, right? Of course. So let's get right to it. I have to give the disclaimer. Neither I, Mike Harber, any of my employees with Harber Appraisal or Crash Talk, or any of the other guests on the show are going to ever give you legal advice. We're not attorneys. If you need legal advice, you need to seek that from a practicing attorney in your local area. We certainly have many attorneys that are qualified and just willing to assist and review a claim. Most of them will do that no charge. Paul's certainly one of those attorneys. So with that, let's go ahead and turn to Paul. Let's hear his conclusion for the 10 meritless excuses. Paul.
For a total loss claim. Yeah, we know that these 5 comparables are priced $1,000 higher than our offer, but we get to take a negotiation discount.
Oh, right.
Right?
Oh, yeah.
Have you ever taken a total loss report from an insurance company and actually called the dealers to find out what the car's sold for?
We have, and sometimes they've sold for less, but that's not verifiable.
I've called, and I've taken a Mitchell report and called, and Mitchell has that typical negotiation discount just across the board.
Right.
Which the report that I saw, the reason I was immediately suspicious was because it was the same dollar figure regardless of the list price.
Yeah.
I thought it would be a percentage.
Right.
Right. If it's listed at $5,500, the 10% discount. No, right. It was one car listed at $7,000, one $5,700, $888 across the board negotiation discount.
Yeah.
So I actually called up, and 2 of the 5 cars they comped, what they took, the sales associate said, "Oh yeah, that was our internet price. We actually sold that one for $1,000 more."
Really?
Yeah.
Huh.
I've called, and they've said, "Yeah, we never actually had that car."
Right.
Right.
I know. We've run into the same. Have never had a vehicle like that here.
Yeah. How often do you handle total losses where your client as a public adjuster comes to you and says, "Yeah, I just put a ton of money into the engine and transmission," and they're saying that's just routine maintenance.
Right.
I just poured $5,000 into this thing.
Yeah.
And they're giving me nothing for it.
Well, even through the appraisal process and the appointed appraiser by the insurance company, what they'll say, well, a vehicle has to have an engine in it. So how come you want to give a benefit because it was a total rebuild on the engine? I mean, it's like a brand new engine now with 500 miles on it, as opposed to it having 150,000 miles on it. Well, you got to have an engine.
Right. But the question is, if the insurance companies are supposed to be basing the value on comparable vehicles, And this comes up in condition too, right? Wear and tear on the seats or the headliner.
Right.
Does Mitchell or CCC1 or AutoSource go out and inspect the condition of the transmission of the vehicles and the comparables?
No.
No. Do we know whether the third comparable on a total loss report also has a cigarette burn on the headliner, and yet it's still listed in dealer ready condition, whereas my Camry is average, so I'm getting dinged?
Yeah. Yeah. No, it's definitely that's why we're so busy with total losses. We're doing still 5 or 6 a week.
Yeah. And this is one where this isn't even an invalid defense. It's just very clever. Yes, I know that all of our comparables are from Yakima and Vancouver, but that's within 150 miles. And so you get that price even though you have to replace your car in King County. Clever. Somebody at the insurance industry was very smart in lobbying for that 150-mile radius for total losses.
Well, we've looked at some of these because sometimes you have to go farther to find a comp. You might even, yes. you may be down in Southern California or Midwest. Well, then what is the cost to get the car here? Wouldn't that be added to the value?
That's an interesting question. Well, no, because hypothetically, you're not actually replacing the car with the comp. You're just using it to appraise the value.
But
right.
But if there are no comps in the local market area and they owe for that comparable value, to get that comparable value here in the local market, it's going to cost an extra $800.
Yeah, but hypothetically, there could be but hypothetically, 5 minutes before the crash, the question is, if instead of getting on the freeway, the vehicle owner had pulled over and said, I don't want this car anymore, I'm putting it on Craigslist right now, then it would have, that particular specimen, that 1985 Fiat that there's only 5 of them left in the country, the DeLorean, would have been in the local market. So hypothetically, its value is what it was 5 minutes before the crash. And it wouldn't have had a destination charge to get it from Iowa if, things had gone just a little bit differently right before the crash happened. So, that one, destination charge, I'm not going to fight you on. But how about diminished value is pure speculation until you sell the car?
Yeah.
Are you hearing that still?
Yes.
Or have people really?
Not as much, but that's usually one of the lines that's in a reply. They'll say that it is just speculation until it's taken place. And
I still see that in, probably 10 or 15% of expert reports in litigation, but just kind of as a toss in.
Right.
I haven't had any experts really want that to be the hill they die on. But how many people does it scare off?
Right.
I mean, we know it's an inaccurate statement of people's legal rights to claim diminished value. They can claim it without selling the vehicle. But how many people say, oh, well, then I just won't bother?
Right.
And walk away.
And how much is that saving the insurance companies whenever they can do that?
Right.
Yeah.
Or, okay. And so I'm getting a couple. All right. So there's all sorts of subcategories of this, but my last one, and I have like 5 subcategories, but I'll just give the overall top one. Well, we know you want to use blah, blah, blah shop you chose, but the shop down the street will fix your car for what we want to pay. So we're only going to pay for that.
Yeah.
And that's parts, labor rates,
Yeah.
this frame bench, that welder, these computer. I mean, you pick the nickel and diming line items on the estimate. It all boils down to, hey, the shop down the street will do it for what we want to pay.
Right.
The implication being your shop is overcharging.
Mm-hmm. How can they limit payment based on that? If they say, well, our shops will do it for our amount. If you want to take it to them, they're going to cost more. So you may be out of pocket.
There is a regulation that says they have to tell you that.
Well, they do. They do tell you.
They have to. There's a regulation that requires them to tell you the shop down the street will fix it for cheaper than the shop you've picked. So if you use your shop, you may have to pay the difference out of pocket. Now they're required to tell you that. The insurance adjusters have interpreted that regulation as permission to pay only what the shop down the street will charge. The language of the regulation itself doesn't give them permission to underpay the claim. It just requires them to warn the person ahead of time that they might underpay the claim. Doesn't make it right. They just have to warn them.
Right.
Be informed. I don't know. And ultimately, the reason they can do it is coming back to what I was saying at the beginning. Oftentimes, the amount in controversy, the delta between the two shops, is so small that it's just like, I don't have time to deal with this.
Yeah.
You know, if put it this way, if an insurance company wanted to shave $150 off my repair, there is no way I could not be more productive in the amount of time it took me to fight for that $150.
Right.
That's just not the fight I'm going to pick.
Yeah.
And they're going to save the money.
Yep.
But no, it's ludicrous. I went to the grocery store yesterday, and the great thing about going to the grocery store is I get to go down the canned food aisle and pick the generic kidney beans. And then I get to go to the dairy section and pick the name brand milk because I like that. And then I get to go to the produce section and choose between organic and not organic. And I can pick name brand this, generic that. I have all sorts of choices about, literally I saved a dime on 2 cans of kidney beans and paid $2 more for name brand milk. And you know what happened when I got up to the check stand? The checker did not lecture me about my decisions because I get to make them. I get to decide what's important to me and what's not. And that's how it works at grocery stores, dry cleaners. That's how it works when you're buying a car in the first place. If you're shopping for clothes at Nordstrom or at JCPenney, I mean, that's nowhere do we hear we're going to make the decision for you about how much money we're going to spend.
Yeah. Yeah.
Except for in that, I can't think of another context where that's the case.
No, it's a very, very strange industry, the way the relationships are all set up. I owned that shop for 25 years, and it took me about the first 3 years to grasp what was going on.
Yeah.
You know, how I've got somebody that doesn't really know about collision repair, nor do they guarantee or accept any of the liability, pay for any of the labor, parts, materials, or anything else, and yet they're going to tell me this is all we're going to pay. And then they'll go and they'll tell their insured or the claimant on a claim that, well, you're going to have to pay out of your pocket because they're charging too much.
And that shop is really hard to work with.
Oh yeah.
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 So ultimately, the one thing that, when I was trying to brainstorm this list, what I was trying to think of were the excuses that insurance adjusters use that are just plausible enough to get people to believe them, and just scary enough to get people to back off fighting in the first place, or shave off just enough that people don't think the fight is worth it.
Right.
And on any given individual claim, it is so easy to put up these excuses. And on any individual claim, the insurance industry doesn't save a lot of money, but they can aggregate that and save billions.
Yeah. Yeah.
For very little effort.
Right.
Not actually raising meritorious defenses,
right.
Meritless statements that are just leverage moves.
Well, you have everything that you've brought up. I think I'm going to have to get with you at another time, and what we need to do is talk about how does the consumer deal with those. Go through, because as you're talking, I'm even making a few notes here. Because the consumer has rights. I mean, I think it starts at, and I've already talked about this several times. The first thing is use your own insurance.
Yes.
Because you have more rights, and this disagreement, there's ways for dispute resolution called appraisal, which is easier than litigation. And the insurance companies, at the end of the day, they understand what their obligation is. If they can shave it off and make it to where you just go away, then they win. But
and everyone everyone also has the right to decide for themselves whether they want to fight. So I'm not as upset about some of the tactics that are so obviously wrong that people have the choice whether it's worth it to fight it. What really upsets me are the tactics that deceive people into thinking they can't fight. And they don't look into it, and so they can't make that choice for themselves. This is worth my time to fight. This is not.
Right.
But regardless, the one common factor is, if someone is going to fight, regardless of the mechanics of it, be it legal, small claims court, appraisal, what have you, get a big bottle of Excedrin migraine, get some Tums, strap in, and be determined, because they want to wear you down and they expect to wear you down.
Yeah.
So that would be the one common thing, is before even thinking about how am I going to fight this, is how persistent am I willing to be? Because the consumer is going to have to be very persistent to win.
Right.
And that's what the insurance industry is counting on.
Yeah.
That's step one.
Yeah.
Is, if I get in this ring, am I going the full 15 rounds?
Sure. Well, and then knowing that there are resources out there. There are people like you. And I know you talk to people all the time, and you will give, just some advice. I mean, obviously you can't give all your time away, because that's what we all have to, that's what we have to sell, right? It's our time. And there's only so much of it.
And I've got a few relatives that live in my house that would like it too.
Right. Yeah. Well, better not go there.
Even if I had 24 hours in a day, I have competing, some folks that would like a little bit of my attention sometimes.
Yeah. Well, Paul, thank you so much. You've been very generous with your time this morning, and
appreciate the opportunity.
Yeah. Well, great. Well, like I said, we may circle back around and come back and just see if we can talk about the other end of the delay and denying. And what was the other word instead of defending? You took away defend.
Discounting.
Discounting. Oh, yeah, discounting. Yeah.
Which I think is more accurate in terms of property damage, because they're not trying to push these claims away entirely. They're trying to nickel and dime 10% off, 15% off.
And they usually are successful at that. You know, we see a lot of wins, but even at the wins, they're still getting their piece.
Yeah.
Right.
So I think it's discounting.
Paul, thank you very much.
Yeah.
Well, that was another good evening, and just the conclusion of the 3-part series from Paul. And I think what I would like to just reinforce and make sure that everybody picked up on this is that you don't give up. Don't just give in because you're told something that sounds authoritative, but do your own research, ask questions, reach out to Harber Appraisal, reach out to an attorney like Paul Vaillant, get the facts, understand what your rights are, and realize that you don't always want to take advice from somebody that owes you money. So with that, stay safe, wear your mask, keep your distance, and look forward to seeing you again same time next week. Please subscribe if this information is good. I don't understand how all this stuff works, but I guess if you subscribe, it just means that we're getting the word out and that you're interested in more information like this. Also, if you go to our landing page, CrashTalk.com, or even here on YouTube, you can send us questions. You can ask questions about information that you're trying to determine, or if you have a topic that you'd like to see us cover. I'm really open to that. We're looking for ideas. We want to know what you need to know so we can try to help. We're here as a resource. So with that, this has been Crash Talk. Good night.